up testimony from witnesses in this hearing and who are about to then offer into evidence a number of documents, a lot of documents, which they're now debating over. And to bring us some sense of perspective of these last few developments, let's talk now to David Cardwell, who's been standing by for us all these long 26 days as an advisor to our coverage of the campaign. David, what do you make of this argument that's underway right now?
Well, where we are now is that the two primary sides have finished with their witnesses. There's still the possibility that other parties, the various counties, or the intervenor, Mr. Butler, may call witnesses. But right now what's going on is that the Bush and Gore legal teams are working to get their documents into evidence. They were put in for purposes of being used with witnesses and for demonstration or for explanatory purposes during the course of the hearing, but now they're trying to get them introduced into evidence. The fight right now is over the 9,000 ballots, the so-called undervote ballots in Miami-Dade County. The Gore campaign is trying to get them introduced into evidence. The Bush lawyers are complaining that they haven't followed the strict rules of evidence to get them properly offered into evidence. So you're going to see some real lawyering start to go on right now.
And David,
they've also indicated, yes.
Well, David, give our viewers some sense of what that would mean then to the timeline here. We all had the sense that perhaps the judge was going to return with a ruling right away, but it looks like now we're into hours and hours of reading on his part if he's going to get through all these documents.
Well, a lot of these documents have been discussed during the course of the hearing, but of course he hasn't had an opportunity to read all of them. I mean, there are hundreds of documents, transcripts of the canvassing board's meetings. A lot of these documents are really being put in the record to preserve them for the appeal. What also is happening is the lawyers are indicating that there are enough issues that have to be resolved on introduction of evidence and working out some of these other evidentiary matters between them. They're talking about having meetings of the two sides' lawyers tonight, work that out, and come back to court in the morning. The lawyers do not expect this to end tonight. Looks like they think it's going to go late into tonight with them meeting after court recesses, and they'll pick it up again tomorrow morning, probably for cleaning up the last administrative details and then going right into closing arguments.
And prior to those closing arguments, David, give us some sense of what's going to happen to those 9,000 ballots. Should they be permitted? Should they be introduced as evidence then? Is that so that the judge himself can look at them and determine whether there was a voter's intent to cast a vote for one candidate or the other?
Well, the Gore team wants them introduced into evidence so they're part of the record of the hearing. As far as where they'll be physically located, they will stay secured. There's what debate that's going on now is, have all of those ballots been properly identified and segregated from the other Miami-Dade ballots. If you'll recall, there was a witness earlier today, Michael Lampkin, who testified there was a discrepancy between reports that had been released by the Elections Department in Miami-Dade about the number of undervotes and the number of ballots that were in the envelopes that were shipped up here on November 29th. So they're trying to also sort through that, because every one of those votes means a lot, and they want to make sure they got the right ones.
David Cardwell, thank you. You mentioned an awful lot of lawyering about to go underway, and now we see there are several lawyers on their feet, so let's listen into what they've got to say.
Is to establish that, in fact, this call did, in fact, affect voters. They did not go to the polls as a result of that.
It'll take about 2 minutes. What's the next witness?
And the last one is an expert witness who will indicate that it did have an effect on the voting in Florida. It will have had an effect on the results, which of course your court is well aware that as one of the things you're looking at to determine whether there's been any effect on the results.
That what had an effect on the overall?
The early call of the election by the press. And
I believe that would be bringing in some extraneous matters to the issues that we have in here as far as that expert is concerned.
My co-counsel, Manny Klausner, would like to address the court on that. May you address the court?
Your Honor, very briefly, our view is that under the applicable section of the Florida statutes, which ask the court to look at all the circumstances and frame a remedy that's appropriate, whatever the court may find has been done erroneously or improperly with respect to the election, that if the court finds there have been any errors whatever, before the court is able to frame an appropriate relief, the word is appropriate remedy under this code, The court...
Well, what you have are some witnesses, apparently, if we get, depending on what type of, I suppose, remedy that would be fashioned, but as far as I know, the plaintiffs have filed a contest to this election on certain specific allegations. The other defendants have defended on those allegations, and these this apparently goes to another matter.
Respectfully, Your Honor.
Yes, sir.
Our view is that under the code, the court may provide any relief appropriate under circumstances. Our view is that this codifies the inherent equitable party of the court. If there were a tornado that wiped out half of western Florida, our view is that the court should consider any act of God or other intervening circumstance as a bearing on a designing
with respect to the relief that these plaintiffs...
That's our view, Your Honor.
I'm going to have to respectfully disagree with you, sir.
May I suggest this, Your Honor, because our evidence is very limited in terms of time. And we've
I'm not going to... Your fact witnesses that you want to present, I will permit those, sir, but we're not going to bring in another statistical expert that's going to, I suppose, have an opinion concerning the effect of as I understand it, an early call by
the networks or the local media.
By the networks, as that might have some bearing on this case. I'm just going to have to respectfully disagree with you. I think that your position is noted in the record, and will be a part of this, subject to appropriate appellate review.
We do have another expert, Your Honor, who would be prepared to testify very briefly on the issue of the use of selective hand recounts in certain counties as diluting, in terms of the overall effect on the statewide results.
Was this witness disclosed to the other party so they've had an opportunity to...
The answer is yes, he has been disclosed, and he's here in the courtroom. And he's
all
ready
right,
to testify.
that one witness. Go ahead.
Your Honor, if I may make a brief suggestion, Miami-Dade County...
Did I hear dissent?
I think so, Your Honor. Miami-Dade County Canvassing Board doesn't care, but maybe as an expert, as a way to speed these processes along, these interveners, first of all, as Your Honor recalls, were admitted and allowed to intervene subject to and subordinate to the rights of the main parties, or else I think there would have been more objection at that time. They have filed an intervener's amended witness and exhibit list. They filed it today. If everyone can stipulate that that goes into the record, it speaks for itself. We don't have to hear from anything else, so we can maybe move on.
I think, Your Honor, I think technically we would have to proffer them for purposes of the record, and I would suggest to the court that a written proffer could be done in order to save the court time.
All right, well, let's proceed. Let's proceed in that fashion. Bring on your fact witnesses at the appropriate time, and then you may proffer the expert testimony.
Your Honor, I have only one party that testifies to stand. If the plaintiffs will stipulate that my client is a voter in Duval County, voted for Governor Bush, and that he has not received any certification of how he voted, that's all I want.
Well, we certainly could agree with that, but he may not have pushed his chair.
Subject to that, he stipulates to your proffer.
Your Honor,
and your client's name, Mr. Jennings, for the record.
Your Honor, there are 5 clients.
All of the names, each of those individuals,
The petition is declaratory 3, and also on the motion for...
All right, let the record so reflect. Mr. Madigan.
All he did was
Your
name
Honor.
the client, is that right?
Actually, he had 600,000 of them.
Mr. Madigan has the floor.
Your Honor, just for the record, I believe we reached a similar stipulation. All his appearances have been through counsel. We don't need for him to testify as long as we are resolved that we do have standing and we have the right to participate in closing argument. We don't need to put him up for further testimony.
What is the stipulation?
That is the stipulation.
The stipulation is that his party is back there in the courtroom and he's who he says he is. That's right, isn't it?
And that he is, yes, sir. He's made his appearance through our pleadings, which have not been objected to.
And that's the same thing.
Or denied, rather.
Same thing we're agreeing to with
All you're going to do is present your witness that he is he?
Yes, Your Honor, and to walk through what we've already said. In fact, we probably could have done it by now, but I was trying to
Well, does he have a status? Are you proffering what your argument was the other day?
Yes, sir. And we did submit the witness exhibit list that essentially said the same thing.
You admitted the witness list, but all that I hear is being stipulated to is to identity only. Now, if you wish to proffer that your client, I believe your testimony or your argument was to the effect that he was a resident of Collier County, that he voted in the election for George Bush, that there was some 3,000 so-called, I suppose, undervotes or no votes in Collier County, and that your client doesn't know whether his vote was counted or not. Is that
yes, sir, Your Honor?
Off the top of my head.
And Your Honor, that he did not have an opportunity to
ask for a recount.
All right, and that he did not have an opportunity to ask for a recount. Now,
yes, sir.
That's the proposed proffer.
No. He's going to proffer that. We're not necessarily going to agree with the proffer.
All right,
and he's prepared to
call your witness.
Okay. I thought we had it.
Ask him to come forward and be sworn.
Please raise your right hand. You solemnly swear that the evidence you shall give on this issue shall be the truth, the whole truth, nothing but the truth, so help you God.
I did.
All right, be seated, sir. You may proceed.
I'll be brief, Your Honor. Would you state your name for the record?
Matt Butler.
Okay. Thank you. And you are a resident of where?
Collier County, Florida.
Okay. And how long have you been a resident of Collier County?
Just over a year.
I'm sorry, I'm hearing objections or?
No.
Huh? Okay, I heard. Okay. Nobody objects if I leading. Mr. Butler, did you vote in the November 7 general election?
Yes.
Okay. And did you have any problems in voting? Did you encounter any problems with the machinery?
No.
And who did you vote for?
George Bush.
Okay. What kind of voting machine was it that you used?
Punch card.
A punch card. And you had no problems?
No.
Okay. Do you know if your vote was in fact counted?
I do not, for a fact.
Are you aware that there were a number of votes in Collier County that were not counted for one reason or another?
I have read that.
Okay. And you don't know if yours was one of them?
I do not.
Okay. Do you know who gained the most votes in the presidential election in Collier County?
I believe Governor Bush did.
Do you have any idea what the percentage was?
I've read it was like 2-1.
Okay. Was there a manual recount conducted in your county?
No.
In Collier? Did you ask for a manual recount?
No.
Why not?
That's not, my understanding, that's not allowed by a voter. That can only be asked for by a candidate or a political party whose candidate appears on the ballot.
So you were not allowed to ask for a recount in any event?
No.
Okay. Are you concerned about recounts being taking place in any other county, Mr. Butler?
Extremely so.
Why does that concern you?
Because it places my vote at a disadvantage. It makes my vote potentially worth less than the vote of someone else's.
Okay. Is that why you've intervened in this cause?
It is.
Okay. Do you want your vote to count the same as any vote in any other county?
I do. The same.
Would you want, if there's a recount in any county, would you want the same thing to be done in your county?
Well, I want the same rules applied to my vote as to anybody else's vote in this state. That's what I want.
Okay. Thank you, Mr. Butler. No further questions, Your Honor.
Any inquiry? All right, thank you. May the witness stand down without objection. Thank you, sir.
One plot.
I think you had a stipulation, or did you?
Well,
I don't know.
wasn't sure about
well, at this juncture, call your witness.
Tried.
All right.
All right, I call Mr. Keith Temple.
All right, is this Mr. Temple? All right. Mr. Temple, allow the clerk, if you will,
Please
to
stand
swear
and
you
raise
in.
your right hand. Do you solemnly swear that the evidence you shall give on this issue shall be the truth, the whole truth, nothing but the truth, so help you God?
I do. Be seated, sir. You may proceed.
Mr. Temple, you're an intervener in this action by